solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Okay, thank you. You can lower your hands. On counsel for the Attorney General's office, please state your name.
Garabetta Carmation.
Okay, and is this a hearing?
It is, Your Honor. It's a hearing.
Okay. A few housekeeping items. The first is I am an associate judge, so you have the right to a de novo hearing before the referring court. Also, nobody should be recording this. There should be no audio recording, video recording, no recording of any kind by anybody, either here on Zoom or watching on YouTube. Also, even though you're in your homes or at work, you should treat this just like you're in a courtroom. That includes staying on camera, not having side conversations. We generally take testimony in court where one of you will be asked questions at a time by the Assistant Attorney General. Unless you have a legal objection, please don't interrupt the person answering. You'll both be given a chance to be asked questions, and you'll both be given a chance to speak at the end, so feel free to take notes. But nobody should be interrupting the other person unless there's a legal objection, and then please interrupt with that objection, and I'll make the ruling on whether or not I'm going to approve it or not. And then lastly, I'm not with the Attorney General's office, so things that you've spoken to them about or given to them, they're not allowed to discuss that with me or give it to me. And so you're probably going to be asked about things you've discussed already. Please just answer the questions to the best of your ability. And Mr. Dehamajian, what are the issues, and can you summarize the disputes?
Yes, Judge. We have a few agreements, but the issues are the child support. Mr. Maldonado does not agree on the amount. And the other issues are the medical support and dental support. Mr. Maldonado doesn't agree on who should be covering the children.
Everyone's ready to proceed today?
Yes, ma'am.
The state is, Judge.
Mr. Maldonado?
Yes.
Okay. What are the agreements?
The agreements, Judge, is that a child support judgment in the amount of $2,749.81 as of December 31, 2025, and that will be paid back at $64 a month starting February 1, 2026.
Just to be sure I heard that correctly, 64? 64?
64.
Okay.
And I'm also going to offer the pay record as an Exhibit A, which the parties are in agreement because it reflects the amount of the arrearage.
Okay, so everyone agrees State's Exhibit A will be admitted?
Yes, ma'am.
Sure.
I'm sorry, was that a yes, Mr. Maldonado?
Yes.
Okay, thank you. State's Exhibit A is admitted.
The parties also agree to the court costs as billed, and Ms. Maldonado has until January 26th of 2027 pay that as billed because we don't know the amount. The health and unreimbursed health and dental is 50-50. Parties agree on that, and I'll call each. Ms. Sandra Rivera, did you hear, understand?
All right, guys. This courtroom hearing begins with a simple oath, but beneath those routine words lies a dispute that has been building for years. As both parents swear to tell the truth, the judge immediately establishes strict courtroom rules, making it clear that no recordings, interruptions, or distractions will be tolerated. Although everyone appears through Zoom, the atmosphere is anything but casual. Every statement from this point forward could directly affect child support, medical coverage, and the future financial responsibilities of both parents involved in this increasingly tense legal battle. Before anyone presents evidence, the judge carefully explains how the hearing will proceed, reminding both sides that each person will have an opportunity to speak without interruption unless a legal objection is necessary. She also emphasizes that she remains completely independent from the Attorney General's office, meaning previous conversations with government attorneys cannot influence her decision. That reminder shifts the focus squarely onto the evidence presented inside the courtroom, where every answer, document, and witness testimony will determine the outcome rather than assumptions or private discussions held before the hearing. The Attorney General's representative quickly narrows the dispute to three major issues that continue dividing the former couple. While several agreements have already been reached, the biggest disagreement centers on child support, followed closely by responsibility for the children's medical and dental insurance. According to the state, the father disputes how much he should pay and questions who should carry insurance coverage going forward. These financial disagreements may sound routine, but they represent thousands of dollars and could dramatically affect both households long after today's hearing concludes. The courtroom finally begins moving beyond procedure as both parties officially acknowledge their first agreements. A child support arrearage totaling nearly $2,750 is confirmed, along with a repayment schedule beginning in early 2026. Additional agreements covering court costs and equal responsibility for unreimbursed medical and dental expenses are also placed on the record. One by one, both parents confirm they fully understand these terms, allowing the judge to admit the first official exhibit before testimony shifts toward the far more disputed issues surrounding ongoing support obligations.
And the agreements, just the agreements that I read into the record, ma'am?
Yes, sir.
And you're in agreement as to those?
Yes, sir.
Okay. Mr. Alfonso Maldonado, did you here understand just the agreements I read into the record?
Yes. Yes, I did.
And are you in agreement as to those?
Yes, I did. Yes, I am.
Thank you, sir. State calls, I'll get back with you, Mr. Maldonado. State recalls Ms. Sandra Riviera. Can you state your name, ma'am?
Sandra Rivera.
Miss Rivera, now the prior order that y'all got into, that was a divorce decree, right?
Correct.
Okay. And in that decree, well, first of all, the decree was signed January 21 of 2022, right?
Correct.
And in that decree, child support was ordered of $800 a month starting January 1, 2022, right?
Yes, sir.
Okay.
If you can speak slower when you say numbers and dates, it's hard to follow all that.
Yes, Judge.
Thank you.
So the child support was $800 starting January 1 of 2022. Right, Ms. Rivera?
Yes, sir.
Okay. And in that order, page 23 and page 25, Mr. Maldonado was to carry the health and dental through his employer. Isn't that right?
Yes, sir. That's correct.
Okay. Now, ma'am, who are your children? Can you state their names and their ages?
Yes, sir. Alfonso Maldonado Jr., age 16. Samuel Maldonado, age 11.
Okay. And how are the children covered for health and dental right now?
Right now, they're covered under my employer.
Okay. And how much does it cost you to cover for the health for the kids?
It's monthly. It's about $150 a month.
Okay. Let's get into. Let me ask you this: for each pay period for the medical, how much is it?
About $70.
Okay. Do you know the exact amount, ma'am?
I believe it's 69. I would have to get it. I don't have it right in front of me.
Is it $69.26?
Yes, sir. That sounds about right. Yes, sir.
Okay. And does that include you as well?
No, sir. My coverage is paid for directly by the district.
Okay. Now, and for the dental, how much is it for the dental per pay period?
Per pay period is $11.51, I believe.
Okay. And does that cover just the kids as well?
Yes, sir.
Okay. And if we're going to translate that to monthlies, just for the kids, the health would be $150 a month and the dental would be $25 a month?
Yes, sir.
Okay. Judge, at this time, I offer State's Exhibit B, which is the health and dental, based on the testimony of Ms. Rivera.
Does anyone have a legal objection to State's Exhibit B? Do you all know what it is?
The coverages for that I have provided.
Okay. Do you have a legal objection to me admitting State's Exhibit B?
No, ma'am.
Mr. Maldonado?
No.
Okay, State's Exhibit B is admitted.
All right, guys, with the preliminary agreements officially locked into the record, the hearing shifts into the testimony that could ultimately reshape this family's financial future. The state's attorney calls Sandra Rivera to the stand, beginning a detailed examination of the original divorce decree. Piece by piece, the questioning revisits what the court ordered back in 2022, establishing a foundation before addressing what has changed since then. It's a familiar legal strategy. Start with the original agreement, then uncover exactly where the situation began to fall apart. As the testimony continues, Rivera confirms that the original divorce order required monthly child support payments of $800, while also placing responsibility for health and dental insurance on Mr. Maldonado through his employer. She identifies the couple's 2 sons and explains that she now carries both children under her own employer-sponsored insurance plan. What seems like straightforward testimony is actually building a crucial timeline, because the court must determine whether the father fulfilled his legal obligation or whether circumstances forced the mother to assume unexpected financial responsibilities herself. The questioning becomes increasingly detailed as the state focuses on actual insurance costs instead of general estimates. Rivera carefully explains what she pays each month for medical coverage before breaking down the deductions taken from each paycheck. Although she cannot immediately recall every exact figure, her testimony remains consistent, showing that the district covers her personal insurance while the deductions relate specifically to the children's coverage. Those seemingly ordinary numbers now carry significant legal weight because they could directly influence future reimbursement orders and ongoing support calculations. With the financial figures now established, the attorney summarizes the monthly costs at approximately $150 for health coverage and $25 for dental insurance before introducing another official exhibit into evidence. Neither side raises a legal objection, allowing the judge to admit the documentation without dispute. That smooth admission may appear routine, but it quietly strengthens the state's position by transforming verbal testimony into documented evidence. From here, the courtroom is no longer debating estimates. It is evaluating verified records that could shape the judge's final ruling.
Now, Ms. Rivera, when did you buy this coverage for the kids?
Coverage started for our boys on my policy effective June of 2023.
And why did you have to buy this policy mid-2023, ma'am?
Mr. Maldonado left his current employer at that time.
Are you saying that the kids didn't have coverage during this time?
Correct.
Okay. Do you want to keep this coverage for the kids moving forward?
Yes, I would like to keep the coverage.
Why don't you want Mr. Maldonado to cover the kids for health and dental?
If my coverage is cheaper, I think it would be beneficial for me to cover them versus having him pay for a more expensive plan.
Has Mr. Maldonado tried to cover the kids for health and dental since mid 2023?
Not that I'm aware of.
Okay. Pass the witness, Judge, at this time.
Okay, you can call your next witness.
State calls Mr. Maldonado. Mr. Maldonado, can you state your name for the record?
Alfonso Maldonado, Sr.
Mr. Maldonado, do you have health and dental coverage for the children through your work right now?
As of right now, no. But all I have to do is get paperwork from y'all, and I could go get it from my company. They're closed until Tuesday or Wednesday because of the weather.
Okay, so Mr. Maldonado, now when did you stop carrying the kids for health and dental?
In June 2023. I left my current job because I couldn't support my current family.
Okay.
Due to child support, insurance, and everything.
Okay. Have you tried since 2023 to get health and dental for the children in this case?
Every job that I've required did not offer insurance.
Okay.
And the job that I have now does offer insurance. I just missed it.
All right. Do you know how much it would be?
No, I do not.
Okay. Now, you said that you have other kids, right?
My current wife has 2 kids of her own.
Okay. So they're not your biological kids.
They're not my biological kids. I'm raising them as they're my biological kids, but they're not mine.
Okay. Now, sir, where do you work right now?
Sprayberry Production Services.
And how long have you been working there?
Since September.
When was your start date?
August 25th.
Of 2025?
Yes.
Okay. Now, you've submitted several paychecks, haven't you?
Yes.
Okay. Judge, at this time, I offer State's Exhibit C, which is the 3 paycheck stubs that Mr. Maldonado has submitted.
Does anyone have any legal objection to me admitting State's Exhibit C?
No, ma'am.
No.
Okay, State's Exhibit C is admitted.
Mr. Maldonado, let's talk about these check stubs that you submitted, okay? The first one, the period beginning December 7th, 2025 and period ending 12/2025.
I see.
You worked 40 hours that week, isn't that right?
Correct.
And your base salary is $17 an hour, isn't that right?
Correct.
Okay. And that week, this stub shows that you worked overtime of 45 hours and 45.53 hours, right?
Correct.
And then on overtime, you get paid $25.50 an hour, isn't that right?
Correct.
Okay. In this particular check, your gross was $18.41.
Correct.
Okay. Now, the next paycheck stub is period beginning December 21 of 2025 to...
All right, guys. This is where the hearing takes a far more revealing turn. The state's attorney shifts away from insurance costs and asks the question everyone has been waiting for. Why did Sandra Rivera begin carrying the children's coverage in the first place? Her answer is direct. She explains that the policy became effective in June 2023 after Mr. Maldonado left his employer, leaving the children without the insurance they had previously relied upon. Rivera tells the court she wants to continue providing coverage because her plan is less expensive, making it the more practical option. Now it's Mr. Maldonado's turn to testify, and the courtroom immediately hears a different perspective. He admits that he currently does not have health or dental insurance for the children, but insists that his new employer offers coverage and that enrollment is only delayed because company offices remain closed due to severe weather. Looking back, he explains that he stopped providing insurance after leaving his previous job in June 2023, arguing that overwhelming financial pressure forced him to make difficult employment decisions simply to support his growing household. The attorney digs deeper into Mr. Maldonado's employment history, asking whether he attempted to restore insurance after changing jobs. He responds that every position he held following his departure failed to offer health benefits until his current employer.
To period ending January 3 of 2026. And here, this reflects a 2-week work period, right?
Correct.
And here you worked a total of 107 hours and 107.16 hours of overtime.
Correct.
Okay.
Were they both 2-week work periods?
No, I worked 3 weeks straight and 1 week off. So I have a 1 week check and a 2 week check every month.
Oh, okay. So you have it.
So I work 1 week, get paid, work 2 weeks, get paid, and that week, that's the 4th week that I'm off that week. So I work 3 weeks straight and then 1 week off. So every time I come back, I work a week, get paid, to work 2 weeks and get paid.
The week off, you don't get paid.
Correct.
Okay.
So, Mr. Maldonado, let's look at the last stub that you provided. It's period beginning January 4, 2026 to period ending January 17 of 2026. And it shows that you worked a 40-hour week, and then you did 57.20 hours of overtime. Isn't that right?
Correct.
So, as you testified, you worked 3 weeks, and then you're off a week, as you said. These paychecks reflect that,
Correct.
Right? Okay.
Correct. And I'm in West Texas, so overtime isn't even guaranteed. I'm only at 60 hours for this week already, for this past week, and the new week already started.
Now, if we take the 80-hour paycheck and we take the 40-hour paycheck in January 4, 2026, if we add those two gross amounts, it's 6502. Isn't that right?
Okay.
Now, if we do a year to date,
Sorry, what are you adding to get 6502?
the gross monthly from the 12/21/25 to 1/3/2026.
I'm sorry, where is 12/21/25? Which page is that?
It's
The
the
second
middle paycheck.
Okay,
It's the
so
80-hour one.
So 4364.58 plus what number?
The third paycheck,
Okay.
which is the 40. That's the 2138.
Okay.
Now, if we do it a different way, Mr. Maldonado, we do a year to date. Now you said your start date was 8/25/25, right?
Correct.
And your year to date on that first paycheck shows 26,659, correct?
Correct.
If we divide by 17, round about where you started in August 25 of 2025, that shows a monthly of $67.95 gross a month. Isn't that right?
Somewhere on that area.
So would you say that you're grossing anywhere between 6502 and 6795 a month at your job, sir?
As of right now, yes. And like I said, overtime is not guaranteed at all. Because if I lose this job and go to McDonald's, y'all gonna take my whole check as soon as I get paid? Because clearly I'm not gonna be able to afford this here, is what you're telling me.
Pass the witness, Judge.
Okay. Do you have any other witnesses?
No.
Okay, the state does not represent either of you, so I'm going to give you both a chance in case there's something additional you think I need to hear.
He also describes his blended family, explaining that while 2 children in his home are not biologically his, he helps raise them as his own. Attention then shifts to his present employment, where payroll documents are introduced into evidence, providing the court with verified records of his recent income. With Exhibit C officially admitted, the hearing moves into a meticulous review of Mr. Maldonado's paycheck stubs. The attorney carefully walks through each pay period, confirming his hourly wage, regular hours, overtime, and total gross earnings. Every figure is read aloud to establish an accurate picture of his earning capacity rather than relying on estimates or assumptions. Although the questioning sounds highly technical, each calculation serves a larger purpose, determining the income level that will ultimately be used to calculate an appropriate child support obligation under state guidelines.
Before I do that, though, would you like to make a brief closing that summarizes what you're actually asking for, Mr. Dehamajan, so they know how to respond?
Yes, Judge. I apologize, Judge. I need just 30 seconds. All right, Judge. So,
One second. Okay, you can continue. I was counting something.
yes, Judge.
Okay.
So the state is asking that you approve the parties' agreements. Number one. The state is also asking that the health and the dental going forward be covered by Ms. Rivera at $150 per month for health, $25 a month for dental, and that Mr. Maldonado reimburse Ms. Rivera these amounts starting February 1 of 2026. The state is also asking that child support be set at $13.10 a month. The way I got this number, Judge, is I took an average of the gross monthly. I used the gross monthly of $66.49 a month, and with the $150 reimbursement for health, $25 reimbursement for dental, at 25%, that would bring the guideline child support at $13.10 a month. And we're asking that also start February 1 of 2026. That's the extent of our request, Judge.
The prior order was 1,071.
The prior order, the decree, the child support was set at $800 a month.
And was he reimbursing cash dental and cash medical?
No, in the decree, Mr. Maldonado was ordered to cover health and dental through his employer. believe it's page 23 and 25 of the decree.
As I said, the state does not represent either of you, so I'm going to give you both a chance. Say anything additional you'd like to say. Mr. Maldonado, is there anything additional you'd like to say?
So how much is the child support and insurance and whatnot going to be? I just want to know
I haven't made a ruling yet, sir.
Okay.
I'm here to still listen to evidence, and actually I'd like to do some math on my own. That's what I was counting. I'm not doing it yet because it's hard to do math and listen at the same time. And
I understand.
And not make a mistake somewhere. So I'm trying to do the best I can to move it along, but I don't have an answer for you yet.
All right, guys. The financial breakdown becomes even more intense as the attorney examines a second paycheck covering a longer work period. The records reveal substantial overtime, but Mr. Maldonado explains that his schedule is far from ordinary. Instead of working a consistent rotation, he spends 3 consecutive weeks on the job before taking an unpaid week off. That unusual schedule creates alternating 1-week and 2-week paychecks, making his income appear inconsistent at first glance. The court now faces the challenge of separating irregular payroll cycles from his true monthly earning capacity. The final paycheck receives the same careful scrutiny. Once again, the documents show 40 regular hours followed by a significant amount of overtime. Mr. Maldonado confirms that the records accurately reflect his demanding work schedule, but quickly adds an important warning. Working in West Texas, he explains, overtime is never guaranteed and could disappear without notice, depending on available projects. That statement becomes central to his defense because relying on temporary overtime could dramatically inflate the income used to calculate long-term child support obligations. Rather than accepting uncertainty, the attorney begins calculating Mr. Maldonado's average earnings using multiple methods. By combining gross income from separate pay periods and comparing those figures with year-to-date totals since his employment began in late August, the state arrives at a monthly gross income exceeding $6,600. Mr. Maldonado follows each calculation closely, even asking the attorney to explain exactly which paycheck figures are being added together. The exchange highlights just how much is riding on every number placed into the court record. As the calculations conclude, Mr. Maldonado reluctantly acknowledges that his current earnings generally fall within the estimated range presented by the state. Even so, he immediately cautions the court that those figures depend heavily on overtime, something he insists could vanish at any moment. Frustration finally breaks through as he argues that if he were forced into a lower-paying job, nearly his entire paycheck could disappear into support obligations. With that emotional statement on the record, the attorney ends the examination, bringing the evidence phase one step closer to its conclusion.
Okay, when I left FedEx because I couldn't help support my current family. Because between child support, insurance, 401k, everything coming out, I'd have a $1,700 check come out to $600. So I left to try to better myself, open my own business. It was going good. Left. It didn't work out. All the little jobs that I've had didn't offer insurance. I finally get a job where I'm supporting my family, and I tried calling child support office to get in child support taken out. Had my HR call, nothing, and I don't know what to do. Of course, I used a little bit of time to catch up on bills because the previous job that I had before this one, where I was only making $15 an hour at 42 hours a week, is when I put myself, try to get a modification, and it took almost 9 months to even get a court hearing or anything. And now that I'm making a little bit more money, that's when everybody calls and wants everything. And like I said, I've been trying to, when I was sitting there bringing home a $600 check after child support and back pay, my check was only about $370 bring home weekly. That barely even covers my rent back home, which is only $1,200. My wife gets child support for one of her kids. The other parent doesn't do anything for his own kid. I'm supporting my family. I'm doing the best I can with my boys. I'm calling them every day now. That's about all I can do. I can't even see them. I work 3 weeks out of the month. I get home Saturday night at midnight, wake up at 1 Sunday, and I have to leave back the following Saturday to be back at work Sunday. I'll be lucky to see my boys during summer for at least a week. Yeah, if I'm lucky. That's it.
Mr. Vera, is there anything else you'd like to say?
I'm not gonna comment.
Using my watch to send messages.
I'm going to render now. I am finding that it's been more than 3 years since the pleading was filed, and that the new child support will vary by more than $100 a month. I'm going to approve and render judgment for the past due child support.
All right, guys, after both witnesses have testified and every major document has been admitted into evidence, the courtroom enters one of the most important stages of the hearing. The judge confirms there are no additional witnesses before inviting the state's attorney to summarize exactly what the court is being asked to approve. This isn't just a routine closing statement. It serves as a roadmap for the final decision. Every recommendation presented over the next few minutes could directly influence the family's financial future for years to come. The Attorney General's representative begins outlining the state's recommendations one by one. First, he asks the judge to approve every agreement already accepted by both parties. He then recommends that Sandra Rivera continue providing health and dental insurance because her coverage is significantly more affordable. Under the proposal, Mr. Maldonado would reimburse her $150 each month for medical coverage and $25 for dental coverage beginning in February 2026. Those recommendations closely mirror the financial evidence presented throughout the hearing. Attention then shifts to the issue that has dominated the entire proceeding: child support. Using Mr. Maldonado's average monthly gross income, along with reimbursement for medical and dental expenses, the state calculates guideline child support at approximately $1,310 per month. The attorney explains the formula used to reach that figure before asking the court to make the new payment effective beginning February 1st, 2026. The judge briefly reviews the previous divorce decree, comparing the original support order with a new request before preparing to hear directly from both parents. With the state's presentation complete, the judge reminds everyone that the Attorney General represents neither parent and offers each side one final opportunity to speak. Before announcing any ruling, she makes it clear that she still needs to review the evidence and perform her own calculations. When Mr. Maldonado asks what the final child support amount will be, the judge declines to speculate, explaining that no decision has yet been reached. The courtroom grows noticeably quieter as everyone realizes the outcome is still hanging in the balance.
Child support arrears in the amount of $2,749.81 as of December 31st, 2025. However, I'm not approving the payout. I'm going to set that payout at $35 each month beginning February 1st of 2026 with step-ups as the child support steps down, which will be announced shortly. Oh, I'm sorry, my camera's not on. Okay. I I am approving the court costs and that Mr. Maldonado will pay those as billed to Galveston County by January 26th of 2027. I'm finding his gross resources are $6,600 per month. I'm ordering, based on the testimony presented, that Ms. Rivera provide the health and dental insurance. And I'm ordering that Mr. Maldonado pay to her cash medical support of $150 per month beginning February 1st of 2026. I'm ordering that Mr. Maldonado pay to Ms. Rivera cash dental support of $25 per month beginning February 1st of 2026. And I'm ordering that he pay child support to Ms. Maldonado of $1,300 per month beginning February 1st of 2026. And the step down for one child will be $1,041. So the state's going to draft the order based on my ruling today, and they'll be circulating it to y'all shortly through DocuSign to review and sign off on.
All right, guys, this is the moment where the hearing becomes deeply personal. Instead of debating numbers, Mr. Maldonado begins explaining the difficult choices that brought him to this courtroom. He tells the judge he left his previous job because, after child support deductions, insurance costs, retirement contributions, and other withholdings, very little remained from each paycheck. Hoping to improve his family situation, he attempted to build his own business before eventually accepting other jobs that offered lower wages and, more importantly, no health insurance for his children. Continuing his statement, Mr. Maldonado explains that it took nearly 9 months before he finally received a court hearing regarding his request for a modification. During that time, he says he survived on a much smaller income while trying to keep up with bills and support everyone depending on him. Ironically, just as he secured a better-paying position, he found himself facing higher financial demands. From his perspective, every improvement in income immediately triggered greater obligations, making it feel impossible to truly get ahead despite his efforts. His testimony grows increasingly emotional as he shifts the conversation away from finances and toward his relationship with his sons. He tells the judge he calls them every day, but rarely gets the opportunity to see them because of his demanding work schedule. Spending 3 weeks away at work followed by only a brief return home leaves almost no meaningful time together. Looking ahead, he admits he would consider himself fortunate just to spend a single week with his boys during the summer, revealing the personal cost behind the financial dispute. After Mr. Maldonado finishes speaking, the judge offers Sandra Rivera the same opportunity to add anything further. She declines, choosing not to make additional comments. With testimony now complete, the courtroom falls silent as the judge prepares to deliver her decision. Reviewing the evidence presented throughout the hearing, she concludes that the legal requirements for modifying support have been satisfied. She first confirms the unpaid child support balance before explaining that, although she accepts the arrearage amount, she intends to adjust the monthly repayment schedule differently than originally proposed. All right, guys. After carefully reviewing every document, every calculation, and every witness statement, the judge begins announcing the rulings one by one. She confirms the child support arrears totaling $2,749.81, but declines to approve the repayment plan requested by the parties. Instead, she orders a reduced monthly arrears payment of $35, beginning February 1st, 2026, with future increases tied to scheduled reductions in child support as the children age out of eligibility. It is the first clear sign that the court has reached its own independent conclusions, The judge then turns to the medical and dental coverage that occupied much of the hearing. Based on the testimony and documentary evidence, she determines that Sandra Rivera will continue carrying insurance for the children because her employer-sponsored plan is the more practical and cost-effective option. To balance that responsibility, Mr. Maldonado is ordered to reimburse her $150 each month for medical coverage and $25 each month for dental coverage, with both obligations taking effect on February 1st, 2026, alongside the updated support order. The courtroom reaches its defining moment as the judge announces the new child support obligation. After evaluating Mr. Maldonado's earning capacity, payroll records, and average monthly gross income, she orders him to pay $1,300 per month in child support beginning February 1st, 2026. She also establishes a future step-down amount of $1,041 per month once only one child remains eligible for support. With those figures placed on the record, the financial outcome of the case is finally decided. Just like that, a hearing that began with routine courtroom instructions ends with life-changing financial orders for both parents. The state is directed to prepare the official judgment, circulate it through DocuSign, and finalize the paperwork reflecting the court's ruling. While neither side leaves with everything they wanted, the judge's decision closes months of uncertainty by establishing new child support, medical reimbursement, and dental obligations moving forward. And as always, courtroom battles don't just end with numbers. They reshape the lives of every family member long after the hearing is over.